All right, so we're going to start today with internal reviews of decisions made by the Department of Child Protection. So what we're going to look at today is how to do an internal review, but also how to then follow on to an external review. So what do you do if you're not happy with a decision that is being made by the Department of Child Protection? So when the department makes a decision regarding the child who's in care, the carers have a right to ask for a review for that decision. So that would depend on a few different things. If you're helping, or this is in particular to you guys, but if you're helping a carer to seek a review, be clear about what decision you want to be changed and why. So in your internal review, you've got the form which is online. You need to be very, very clear about what the decision is, because obviously there's a little bit of, I guess, sometimes there's some questions on what actually a decision is, and we need to be very clear on that. So once you've got a decision, whether it's a child being removed from a residence or a child changing schools, anything like that, even as much as food changing, to be quite honest. So a child might have allergies, and you think actually the child needs to be on gluten-free, things like that. You can challenge those decisions. So anything that is in relation to a child, if you need to, if it's not in that child's best interest, we need to be challenging those decisions. So obviously the request must be in writing. That's online. So we need to go to the Department of Child Protection webpage where they have that online form. It's best for the advocates, obviously, to maybe call you guys to make sure they, one, have a decision, but also that it's reviewable. So we need to make sure that those two things are happening. You've got a very strict time frame. So when a decision is made, you've only got 30 days from the decision to review it. That's it. So once the 30 days are up, you're pretty much done. You could ask for an extension. It's possible. Don't waste your time and go over 30 days. It's just not worth it. Especially if you get denied. Okay, so we go into the act. So who can request an internal review? You've got a few different people. So a person who is aggrieved by a decision of the Chief Executive or Child Protection Officer under the Act is entitled to review of the decision under this section. So basically, an application review must be made in a manner which is determined, so that must be in writing, must be made within 30 days. On an application of review under this section, the Chief Executive may confirm, vary or reverse the decision. So in the internal review stage, you would request that a decision be changed. So for example, if it's a child being removed to a different school, maybe you would ask that the child go back to the original school. They can vary that decision and maybe put the child back in that school, or they can reverse the decision, so vary it. So maybe childcare or something, maybe, you know, all those different things that they can do, but they can also confirm the decision. So if they're saying no, that child needs to stay in this school because we have these reasons, they will confirm that decision and the child will stay in that school until you pursue the matter. So that's really what they do: confirm, vary or reverse the decision. Okay, so can they be reviewed? So most decisions, and I've already touched on this, but most decisions can be reviewed under the Children and Young People Safety Act. There's a whole group of other decisions as well that can be reviewed under Chapter 7. So the Chief Executive decisions in relation to the approval or cancellation of approval of carers, they can also be reviewed under the Act, and the only person who can actually apply for that is the person who has been denied being a carer or the approval of a carer. No one else can do that. So under Chapter 7, there's a whole list of reviewable decisions, which include decisions of the Chief Executive under Section 7, so approval of carers, foster care agencies and children's residential facilities, they can all be reviewed. Placement, education and medical arrangements for children and young people. So if the child is placed in a place where we don't agree, for whatever reason, we can review that decision or ask for a review. Education, so if the child is, say for example, the child is moved to a different area and you want the education to the educational facility to be changed, you can ask for that child for the schooling to be changed. That's happening very frequently. So I would encourage you guys to look into that. So for example, there's been a few matters recently where the department has been requested that they move. Say for example, the child was placed at Enfield and then was placed at Enfield from Hackam West, say, down south. So they've asked for the child to go into private schooling and it's been approved. That happens really frequently, even though the child may have come from public schooling. It makes sense that the child doesn't have to travel an hour, obviously, to go to schooling. You also have medical arrangements for children and young people. Those decisions can be reviewed, and that's what I was talking about, maybe like if the child has a gluten intolerance or just general medical arrangements, they can be reviewed. Review of circumstances of children or young people. That can be anything really. So you have a lot of options. Directions not to communicate with or harbour or conceal. So for example, you can review a decision where a child is not to communicate with a cousin, for example, because they may think that I'm not sure that person may be a risk to that child, but they've got no evidence. You can review that decision. Suitability of long-term guardians, that's also reviewable. Financial or other assistance to approved carers or others, and assistance to eligible care leavers. So all those things are reviewable, so that's probably a good slide to keep as reference. It will just make it easier when we're going through internal reviews. Timeframes, as I've discussed, you have 30 days to seek an internal review from the decision being made, and it can be submitted in person, by post or by email, but it's on the website for you to review. Sure. You have a question?
We often, around the 30-day requirement, we often ask for the decision in writing first.
Yep.
So then we say that 30 days begins when the decision is received in writing.
As in when their decision is received in writing?
Yeah, when the department's decision is received in writing.
Yes, that's right. Yeah. So, well, yeah, that's tricky. You could argue that the 30 days would start from the point in which it's in writing to which it's received. They could also argue that it could be from the date that they spoke to you on the phone and gave you that decision. It's grey, yeah.
We've never had an issue with it, and we have waited for some time to receive the decision in writing.
Yeah, okay. Yeah, that's a really great area. As I said, always, it's better to make it, like for your time frames, it's better to obviously make it from the date on which you heard it, that decision being made, because that's actually when the decision was made. The writing is a subsequent from that decision. So if I was representing, I would argue that it's actually from the date of when we informed you, not from the date in writing. So I would always go from the first date because it gives you leeway.
That's helpful actually, because sometimes if you look at the date of when the decision was made, it's well over 30 days gone by.
Oh, 100%. Yeah. So always sort of, if you can, go from the first one. But in saying that, if you get to a point where it's over 30 days, but the day from which you received it is within 30 days of that in writing, absolutely still lodge an internal review. Still do that, but they just be prepared that they may come back and say, well, it's been over 30 days. But I don't think they're very strict on it at the moment. But as more and more of these come through, they might be. So be aware of that, So if after the internal review is complete, a person is still unhappy with the decision, they may apply within the next 28 days for the decision to be reviewed by SACAT, which is the South Australian Civil and Administrative Tribunal. An extension of time beyond 28 days may be allowed. So if there's exceptional circumstances, SACAT generally will allow an extension of time. They're quite good at that, but don't rely on it. So obviously always stick to the 28 days, and For example, if you can't apply because you've been hospitalised, well, of course they're going to give you an extension. If you can't apply within that period because you've got mental health issues and you've really, you've been stretched and you just haven't been able to do it, they're going to give you that extension, okay? So they're very good like that, but don't rely on it, is the key message, because they can still deny it and then you'll be stuck. Okay, so SACAT, South Australian Employment Tribunal, I've edit that out. I'm used to doing workers' compensation. This is the other tribunal. Okay, South Australian Civil and Administrative Tribunal. So it's a state tribunal that helps resolve issues within specific areas. So obviously this is where where we'll go to obviously challenge the decisions made by the Department of Child Protection. So specifically, SACAT is the place to bring certain civil law disputes, applications. So they have a whole range of areas there. They also do tenant relationships, guardianship and administration matters, mental health and consent to treatment orders. They also do community housing decisions. They're looking to do, in the near future, equal opportunity matters, and obviously can review decisions made by the Department of Child Protection. Okay, so this is what the building looks like. So it's on Pirie Street, it's quite large, and there's the contact details for it. So if you need to email a tribunal member at SACAT, that's the email address you would use. You just use the basic one, and then it gets forwarded to the correct member. So it's on level 4, 100 Pirie Street. And there's just a bit of information about the SACAT structure. So that's sort of how it's sitting at the moment. So you've got a few deputy registrars. You have the 3 different streams, which is the housing and civil, the community, and the administrative and disciplinary stream. You've got the president, the principal registrar. She's probably the person that we would go to if we have any major issues, or the deputy registrar. So the principal registrar at the moment is Anne Lindsay. I don't know if you've had much to do with her, but she's amazing. And you've got a whole load of other people, really. There's quite a few members at the moment. You have full-time, part-time and sessional members. And the sessional members are basically when they call upon them when they need them. So they're just sort of, I guess, casual members there. And they have a array of backgrounds. So all members must have a minimum of 5 years experience to sit on the tribunal as a member. And you have full-time, part-time members. Most of them are barristers. There may be a few solicitors in there, but you need a law background. So they have to be lawyers. Okay, so external reviews of decisions. So obviously once you're not happy with the internal review, that's when you will start to look at lodging an external review of the decision. So what's an external review? An external review is where an application is submitted to the SACAT to review a decision that has been made by the Department of Child Protection. SACAT will be looking at whether the Chief Executive made the correct and preferable decision. So that's under the SACAT Act. Who can apply for an external review? So under the Child and Young Person Safety Act, you have a few different people who can apply. You can... Okay, so Section 158 sets out the applicants for approval of carers, foster care agencies and residential care facilities. So that's if you're going to review one of those decisions. In relation to general matters, the applicant in respect to internal review of a decision. So that person could be the child. If the child's not happy with the decision that's been made. It could also be the carer. So any other person aggrieved by the review of a decision who has sufficient interest in the matter. That is the section in which carers would be able to review the decision because they have sufficient interest in the matter. Okay, and a child and young person about whom the review proceedings relate must generally be given an opportunity to personally present their views at the tribunal. Now, we would obviously use that with our discretion because obviously if it relates to a baby, you're not going to bring a baby, or a young child is questionable, and even a young teenager. I guess at this point you kind of need to use your discretion and think about, is it going to be in that child's best interest to present at the tribunal? For a number of reasons, obviously past trauma, going to a court. They've probably been to a court before and it wasn't a good outcome where they may or may not have been removed or had to give evidence. So obviously in those circumstances, putting a child back into a courtroom is not going to go well. We haven't had one yet, but I would possibly suggest that maybe if the child wants to participate, but you don't think the child's really appropriate to be in that environment, maybe the child could write a letter. I would think that would be a good idea. Again, you just have to use your discretion and if it's going to be in that child's best interest.
We've got a current SACAT case where the carers I'm working with are party to the proceedings. It's a little bit different, this one, because they're party to the proceedings on the side of DCP.
Okay.
And
the carer is?
The carer that we're working with.
Okay,
and
yeah.
then there's kinship carers on the other side,
okay,
who actually made the application in the child's name.
Okay.
The child's 10 years old, and in the last hearing the discussion was whether the child should stay as an applicant, because also the carers can also
bring the application.
Yeah,
that's quite, yeah. So, I mean, I don't know if a 10-year-old child would be appropriate to be a party to a proceedings.
The tribunal
didn't think so.
Wasn't very happy about
No.
it. So we're coming back in January and looking at, they're going to have to bring some, like a alternative to.
Yeah, and I think that's a lot of the time is strategy as well, bringing the child into it. Yes, the child does have a say, absolutely. Under the Act, the child has a voice, so that's fine. But is it in the child's best interest? And that's probably, it's the same as going back to the family law principles, is it in the child's best interest that you bring this child into these proceedings? Maybe not. Maybe it is. It just depends on the child and the circumstances. But that one sounds messy. But yeah, so that would be, that's another way to avoid it, is that the child could participate by writing into it. But you can join a child as a party to proceedings. But if you've got a carer representing the child in that, you probably don't need the child to be a party.
Yeah.
So the child could still have a say. It doesn't need to be a joiner in the party. Okay, so how do we submit an application? An application for an external review. These are quite long. So external reviews are submitted via the SACAT website. So SACAT is paperless, which is great for the environment, but it does make it a little bit difficult at times when going through and navigating the system. So it is quite extensive. It can be quite time consuming. There are a lot of different slides. So I think we're going to, in the near future, do one for the carers, like a mock one, so that we can go through, because it's. Do you have a question?
And I was just going to comment about that.
Sure.
No, you finish what you...
Oh, that's fine. So I think we're going to do that, because I think it is quite extensive, and it's one of those ones where I don't think you can save it halfway through. I think you have to go from start to finish. Yeah. So if you don't have 20 minutes to do a SACAT application, you're going to have to do it again. So.
The one that I did, I think it was helpful to go in, provide the initial information so that the file is there.
Yes.
And then note all the different questions and information, and then I did a Word document.
That's a great idea.
And cut and pasted into that area.
Yep.
For that reason.
That's a great idea, because, as I said, you can't save it. So and going back, I think. Even if you go to the back function and
in
around.
working with the carer, they also then can see the question and they finalise the information as well along the way. So it's a joint document that you're actually building before you actually submit anything anyway.
Yeah, that's right. So I think that's probably a better way to do it. I think I've taken screenshots of all of them, and it was a lot of screenshotting. Yeah. But what I did was copied all the big sections of the questions to ask, so that we can go through and go, okay, that's how you would do it, and then you can use the Word.
Right.
So I think that's probably a good way.
That would be good.
Yeah, I think I've got that somewhere on my
And
notes.
I also found one time when I was doing a SACAT application, the system wasn't working at all, and I called SACAT, and they, I did it manually, or they put it in manually over the phone with me. So
Great. Okay, well that's a really good option too. I don't know how often that would happen though. That would be nice for them to do it all the time, but I don't think they have the facilities to do it all the time. But the other option as well is obviously a lot of people don't have computers and don't have access to this, so obviously they can they come here to do the SACAT application? Okay, so they can come here, so carers can come here to do that application, or the other option is that they have the computers that are specifically linked up to this in the SACAT building. So that's another option. And they have coffee facilities, so you can sort of do your SACAT application and have a coffee there. Yeah, so
that's actually a really good option for us as an advocates team to work with a carer around the information and then potentially to meet them at the building, upload it with them there so that then they can see the building, they're familiar with the space.
It's a good idea. Yep.
Yeah.
That's like free coffee, it's good coffee, definitely had some there. So
and they're also then the ones that are finally submitting it.
yeah.
Yeah, and then you can get a bit of a feel for, for what the rooms look like, I guess, as well. And it sort of takes away the scariness of going to the tribunal because it can be a bit overwhelming. So you complete all the main sort of information, and then you're asked if you want to upload any additional documents, the medical reports. So at this point, what we really need to stress is that your other party, which is the Department of Child Protection, who is being represented by the Crown, which are the lawyers for the Department of Child Protection, they have a list of information and evidence that is going to be ridiculously big, because usually these children have a lot of history, and that's what they're putting forward as their case. So being non-legal people, you just need to be aware of that. They're going to come in guns a-blazing with all this information, and it's going to be overwhelming because it's so much information. So what you need to do is, my advice would be to document everything from the moment that there's even a slight issue, even before you need to internally review everything, document everything. So if there's issues going on and you think, I'm not going to complain, it's just a one-off, just document it anyway, make a note of it. Because later on, it's building a case for potentially that this is going to happen. And then you've got that information to go in and say, well, actually, this all started in 2009 and we're in now 2019, and you've got that timeline of events. It's very hard to then go back and start going, okay, let's look back then, and you're not going to remember dates then. Oh, this person came to my house, I can't remember, may have been a Saturday. It's not going to be helpful to the tribunal. They want dates, they want times, they want who was there. That's the information they need. So start document. I document these things all the time, and especially for foster carers and kinship carers who have a lot of issues generally with DCP, just document them. Keep a book, there's a book, keep all the information in there. And then you can upload them. The other thing as well is, with the documents you want to upload your medical reports, get reports from the GP, get reports from the psychologists who support your matter. Get reports from the principal, the counsellor, people that have direct contact with this child that support your matter. If DCP is saying, oh, well, the child's not thriving, we're going to remove the child, get certificates from the school that say the child is doing amazing, that the child's excelling in sport, and home life is great, and report cards, and it's not just evidence on reports. You want to be building a whole case around that child. So I would be, even photos of the child, hanging out with the cousin, looking happy and playing, things like that, because then not only does it show the tribunal member what's actually going on real life, but actually shows that this is a real child that we're talking about. These decisions are actually affecting a real child. So I think that's really important to personalise it, because at the moment the members are getting these applications and it's an administrative decision. So they're looking at it at facts alone, and probably for them it's not personal. they're not seeing the child. You know, in the youth court, they're well aware that there's a child behind the scenes and they have a lot of experience in child protection. These members don't have a lot of experience in child protection, so we need to make it, you know, you need to be able to show them a bit of empathy with who this child is, okay, and what's going on and why this decision is wrong. So this is really the opportunity to present your whole case. So as I said, you want everything possible, you know, reports, photos, even statements from friends who see the child and, you know, if they're saying that the child doesn't look healthy, you know, a cousin that comes around every Tuesday and, you know, and looks after the children and feeds the children says, no, you know, this is what I say, do a statement. It doesn't have to be a stat deck. It doesn't have to be in a legal form. It can just be a letter from that person supporting your decision, whatever it is. You have to use, I guess, you're not going to have a lot of legal avenues and you're not going to have access to a lot of medical reports and things like that. So you need to, I guess, rally your group around you and your support networks and try and build a case like that in non-conventional ways, I think. Okay, so this is what I've just touched on. So what types of documents should you upload? Medical reports, school reports, certificates, photos, counsellor notes. They might not give you those. It depends on the situation. Some counsellors will give a note about what's going on with that child at school. Other ones will be a bit funny about it. So it just depends, but you can always approach them. Affidavits, statements from carer friends. Reports for any professional services, school newsletters. I think that's really good too because often they put photos of the children in the school newsletters and what they're doing. Even if they don't, it just shows what the child's doing in their educational life. Letters of support from family members, previous letters received from the Department of Child Protection. The list is endless, but you always need to upload the decision that you're disputing. That's number one. That has to be uploaded. Okay, so that's the end of those ones. Now I'm going to show you the SACAT stuff, which is a little bit more. So prior to the hearing dates, this is a real basic guide. So once you've lodged an application for review with the SACAT Tribunal, you'll be sent a letter from SACAT outlining the date and time of the scheduled hearing and who the member will be hearing the matter. So you should be provided with all documents prior to the hearing, but in my experience, the lawyers generally give it to you on the first return date. So once you have that hearing listed, you can then at that point ask for a further hearing to be able to review those documents because no doubt they're quite large. Sometimes as well, just to be aware that they won't have all the documents ready by the first return date. That also happens depending on the volume of documents that they are preparing and how much time and staff they have, I guess, at the time to prepare all these documents. So it can be quite extensive. So sometimes they'll ask for an adjournment of a few weeks, a month maybe, to be able to get all those documents. So I guess a lot of carers assume that they're going to get those documents prior to. It's completely normal to get them on the first return date. It's incredibly frustrating, but it's normal. So the lawyers from the Department of Child Protection, they're called the Crown. They should provide the documents, which is what I was saying. So they'll provide the original decision, the documents relied upon to make that decision, and all other documents that they intend to use as evidence during the hearing. So they can be quite extensive. It can be the whole child's history. It will just depend. Also, before we get to this stage, you would have already lodged all your documents, which is what I spoke about before. If by chance you forget and you bring a document with you and you forget to lodge it, you can lodge it there and then with the tribunal member. That's no problem at all. Just remember to apologise to him or her as a courtesy. So on the day of the hearing, you'll probably arrive about 15 minutes before the scheduled hearing time just to get yourself familiarised with your surroundings. You'll enter the SACAT building on 100 Pirie Street. It's on level 4, the sign-in, and there's a registry staff desk right at the front. So you go up there, you sign in. It will just have your name and your signature. They'll ask you which matter it is in relation to as well. So there's many conference rooms on levels 4 and 7. Generally, these matters are going to be heard on level 7, which is also where the guardianship hearings are heard as well. So it's more the community focused hearings, I think, that they're going to put on level 7. There's waiting areas located in front of all the rooms. There's also coffee making facilities. There's computers if you need to lodge some further documents. There's toilets. There's a baby change table on level 4, but not on level 7. There's currently no Wi-Fi, unfortunately. I don't know why. So it can't be accessed by the public. So all hearings are open at the moment to the public. When I spoke to the Deputy Registrar about this the other day, I said, what's going on? Because they are all open hearings. He said that due to them all persons having to sign in before they go to the hearing, it's probably pretty likely that those other additional people, if they were to turn up, wouldn't be allowed in unless they had the members' approval. So even though they are technically open, they will monitor what's going on and who's coming in the building. There's also, if you are concerned as well that someone is going to turn up, it's always best to let registry know, and also they'll notify security. I've had that a few times, even as a courtesy, or is it courtesy? What's the word? Courtesy. Just to let them know, because especially with these matters can be quite hostile, and you just don't want it to be nasty. So, and you want to make sure that you're safe. Okay, so the tribunal rooms are quite small and they're set up like a mini courtroom if you've been in one of those before. So the tribunal member sits at the front of the room behind a brown desk and it's elevated slightly from the rest of the room. And there's a long bench at the front of the tribunal where the parties sit. Generally, the carers and advocates will sit to the right and the Crown, which is the lawyers for DCP, will sit to the left. And there's also seats in the middle as well. That is what it looks like. I've obviously left some girl's jacket in there, but that's what that looks like. So you've obviously got the bench at the front. Now this is a smaller room. There's actually bigger ones also, but this is quite a small one. As you can see, there's water on the table as well, because everyone gets dry mouth on these matters because it gets a bit intense in there, and there's tissues and things like that. So where you have, you also notice there's a Bible on there. And so when you first, I'll go through this more in detail in a minute, but when you first go in and the member speaks to you, he gets you to either affirm or swear on the Bible, but they're on the table as well. And also behind, you can see these chairs at the back, that's the gallery. So if you, that's where generally the advocates would sit, unless they're in a speaking role, they would obviously sit at the bench, but if they're not, they sit in the gallery, which is behind. The hearing process. So once all parties have signed in with the registry, the tribunal member will call out the name of the parties to enter the room. When everyone is seated, the tribunal member will advise the room that the hearing is being recorded and will start to swear in all parties. And as I said, you can affirm as well. I'm sure that they would maybe have a Quran actually. I'm not quite sure you could request that if that was the case. They would have different types of religious Bibles, I'm sure. The member will ask all parties to swear in, reply with I do, and the tribunal member will then inform all parties that they have read the application and ask the carer and advocates why they've lodged the application. So that's really where it starts. So this will be the first opportunity for the carer and the advocate to speak to the tribunal member, and also the best time to raise any issues before commencement of the hearing. So if there are documents that are missing or not provided, this is your time really to sort of ask for those documents. The carer advocate can then ask the matter to be adjourned if they haven't been provided with those documents to a later date, and they have the opportunity to review the documents and provide further response. So that's probably what you would do regardless, because you're not going to be able to give any advice or know what's in the documents until you've had time to review them. Also, the members, so I refer to them as tribunal member. When you're speaking to them, you can refer to them as sir or madam. They're not judges, so you don't need to say your honour. A lot of people do that, but you don't need to do that. They definitely giggle when you say that. So I think from my experience, the Crown refers to them as tribunal member. You don't really need to do that. You can just say sir or madam. If there are no issues to raise, then the carer or advocate will inform the member why they say the decision is wrong, provide them with their thoughts, opinions, facts, evidence if not already provided, and what they want to change or achieve. So for example, if you want the decision to be set aside, so the child can stay with the carer or not change the location of the school, etc. And that was what I was talking about earlier. If you want their decision changed or varied or confirmed, which obviously you won't want it confirmed. The member will then ask the carer or advocate questions at times. So to clarify, he's going to ask you questions. So it's also important to note that when the member speaks, the carer or, when the member speaks, the carer or advocate stops talking immediately. It's just a respect thing. Even if it's partway through your sentence, just stop. It doesn't look good if you start speaking over the top of the member. And not only that, you're not going to win friends. They're not going to appreciate you doing that. There are no rules of evidence in the tribunal, so all opinions, thoughts, facts can be presented to the tribunal. And that's, as I said earlier, documents can also be brought in, so school reports, photos, medical documents, etc. The member will then ask the Crown to provide a response and ask questions to clarify any issues that he has, and that might go on for a little while because generally they have big responses. It's important to note that all tribunal members, lawyers and other parties know that the carers and advocates are not lawyers and not legally trained. So if you don't understand, just ask for it to be explained. That's completely normal. We actually expect that. And also, you know, you don't need to pretend to be a lawyer and speak legally. Just speak how you would speak normally. It's completely fine. Who can give evidence at SACAT? So you've got a few people that can give evidence. So you have a member of the child or young person's family, a person who has at any time had the care of the child or young person, and a person who has counselled, advised or aided the child or young person. So that's quite broad. So any person that's counselled, advised, well, that could be a soccer coach. If you think that that person needs to give evidence to what's going on, it could be the young person's soccer coach. It could be a counsellor from the school, you know, anyone who's advised the children. It could be a friend, it could be an auntie, it could be absolutely anybody. It's very broad. The member will ask the witness to swear in. So once you've organised, I guess you want to make sure that you've got people there supporting your case if it goes to this matter, goes to this point. And if you've got people who are supporting you and witnesses, they will ask the witness to swear in and affirm, as I've already said, and then they'll give them an opportunity to provide the evidence, and then the tribunal member will ask questions. An important thing to note is that I probably need to do a slide on this as well, but witnesses is really important. So if you're bringing in a witness, you need to know what they're going to say before they go to SACAT. So with lawyers, whenever we have witnesses, it's called proofing them. So basically what that is going out and finding out what their story is and what they're going to say, because the last thing you want is for them to be giving evidence that's against your decision, okay? So you need to really be thorough on what they're going to say, what their opinions are, sure.
That would be the responsibility of the legal representative, wouldn't it?
Well, it depends if you're advocating or not. It depends what your role is to think about, but it's very important for carers to understand that, because it can, you know, you could come in with an army of people, but they might not be very credible and it might give the wrong impression. So just be aware of that. So once everybody has given their evidence, both sides and all the witnesses, then the tribunal member may inform the parties of the decision at that point, or what they can do is say, we're going to make a decision, that's fine, but it may happen within the next 2 weeks. And we're not going to make it right now. So it might give them time to think about what's actually been said and then write up the decision. And then at that point, they will post it out to you, and then you'll know what's going on. But they're pretty quick. Usually it's probably not a few weeks. Usually it's a couple of days. But if it's a real complex matter, it may take a little while.
So the case that I'm working with, it went to SACAT, first hearing, it was redirected for mediation.
Okay, that's good.
It was really good.
Good, okay. So
that process is now underway as a side thing.
Did you request that?
No, the tribunal member offered it.
Right, brilliant. Okay. That's what we've been pushing for.
And if it doesn't, if there's no outcome from that process,
goes back.
Go back to to a formal.
Yeah, that's right. And then we'll go back. So, so what we've been pushing for behind the scenes is for SACAT to be really looking at mediation as first and foremost, because you get better outcomes with mediation. That's the reality.
This is the first one we're going to be doing relating to
Yeah.
this legislation.
Good. Okay. So yeah, so we've definitely been pushing that because it makes sense. You know, it's about a child, so let's have a roundtable discussion to be able to resolve it, rather than going into a court, which is an adversarial process, and it's scary for people and it's horrible, and you know, it's not ideal. If you don't need to be here, you don't have to be. You know, it's much better to have ADR stuff and yeah, alternative dispute resolution matters like this. So that's great. I'm glad they're doing that. We have to keep you updated on the outcome. So after the hearing, so once you have the decision in your hands, if you're not party, the next step is the appeal to the Supreme Court of South Australia. You just wouldn't do this on your own. This would be a lawyer barrister scenario. Look, you just wouldn't self-represent ever. It's costly, it's expensive, it's time consuming, but sometimes it does need to happen. There was one recently that went to the Supreme Court. So there's definitely lawyers out there who take on these matters and that can get funding for them as test case, because it's a new part of the legislation. So it's always, if it's at this point, you would want to be speaking, I guess, to you guys about where they go next.